Good afternoon. My name is Renee Townsend. I'm a partner at Seacrest Wardle. Today's webinar presentation will discuss how the gay marriage ruling affects auto accident cases in Michigan. We'll start with a short review of the legal history leading to the gay marriage ruling in Obergefell v. Hodges, which is the U.S. Supreme Court case that legalized same-sex marriage throughout the country. From there, we'll discuss what specifically insurers should know about how that ruling affects Michigan auto accident cases. While gay marriage has now been the law of the land for about 6 months, many insurers and insureds in Michigan are still uncertain of the effects of this change. Same-sex couples were previously denied over 1,000 rights and benefits that stem from a legal marriage. The implications of this ruling are far-reaching, affecting everything from health insurance to property rights and even Michigan auto law. Just by way of example, same-sex marriage made it possible for legally married individuals to file suit as the next friend of their same-sex spouse. This was simply not an option prior to Obergefell. So just because it's kind of interesting, we'll begin with a very brief review of some basic events in U.S. history that led up to the Obergefell case. While the pace at which same-sex marriage became legal throughout the country seemed to happen very quickly between 2013 and 2015, most LGBT scholars agree that the single most important event leading to the progress of LGBT rights in the U.S. began in 1969 in New York City at the Stonewall Riots. The Stonewall Riots were a series of demonstrations by members of the LGBT community against a police raid that took place on June 28, 1969 at the Stonewall Inn, which is a gay bar located in Greenwich Village. From there, the gay rights movement made slow but steady progress from the 1970s to the early 2000s. However, there were several legal setbacks in between. One such setback was the Defense of Marriage Act. Signed into law in 1996 by President Bill Clinton, the Defense of Marriage Act, or DOMA, was a United States federal law that prior to being ruled unconstitutional, defined marriage for federal purposes as the union of one man and one woman, and allowed states to refuse to recognize same-sex marriages granted under the laws of other states. That law led to at least 30 states enacting their own bans of same-sex marriages, civil unions, or domestic partnerships in the early part of the 21st century. Michigan in particular had one of the most restrictive gay marriage bans in the country, which stated that Michigan would not recognize any marriage or similar union between a same-sex couple for any purpose. That law became even more broad when in May 2008, the Michigan Supreme Court held that the amendment banned not only same-sex marriage and civil unions, but also public employee domestic partnership benefits such as health insurance. DOMA remained good law until Section 3 of the Act was struck down in 2013 in United States v. Windsor. In Windsor, the U.S. Supreme Court held that restricting the U.S. federal interpretation of marriage and spouse to apply only to heterosexual unions was unconstitutional under the Due Process Clause of the Fifth Amendment. While Windsor was working its way through the courts, dozens of other lawsuits were filed on behalf of same-sex couples in states all over the country, including Obergefell v. Hodges, seeking to strike down the state constitutional amendments banning same-sex marriages. On June 24, 2015, the U.S. Supreme Court issued its opinion in Obergefell, with Justice Anthony Kennedy writing for the majority in a 5-4 opinion. Justice Kennedy wrote that marriage is a fundamental right and that any state law which bans same-sex marriage is unconstitutional, thereby, in one fell swoop, legalizing same-sex marriage throughout the country. So, with the knowledge of that kind of interesting background, we can move to what we are really here to discuss. How does this case affect Michigan auto law, and what should insurers be aware of in their claims when dealing with legally married same-sex couples? Specifically, with regard to Michigan auto cases, there are several issues which impact insurers and insureds in the post-Obergefell era. The most obvious implication involves the spousal benefits and resident relative provisions in Section 3114 of the Michigan No-Fault Act. Pursuant to MCL 500.3114, an automobile insurance policy applies to accidental bodily injury to the person named in the policy, the person's spouse, and a relative of either domiciled in the same household, if the injury arises from a motor vehicle accident. Prior to the Obergefell decision, a same-sex couple in Michigan had absolutely no status under the spousal benefits and resident relative provisions. These provisions simply did not apply to those same-sex couples, regardless of where they lived or whether they were married in some other state or country. Legally married same-sex couples can now qualify for these provisions. But the key is legally married, so this does not apply to domestic partnerships or civil unions. Moreover, because the Michigan gay marriage ban prohibited the recognition of a same-sex relationship for any purpose, coupled with the fact that Michigan also bans second-parent adoptions, the children of same-sex couples were often excluded from the resident relative provision for at least one parent. After the Obergefell decision, legally married same-sex couples and their children fall within the purview of resident relative coverage. It's important to ensure, however, that the children of same-sex couples were either 1. Born during the marriage, 2. Legally adopted by the second parent, or 3. Have a birth certificate with both parents legally named on that document. This same principle applies to survivor's loss benefits under MCL 500.3108. Under that section, a decedent's spouse and children are entitled to certain no-fault benefits payable for a survivor's loss, which consists of a loss of contributions of tangible things of economic value. After Obergefell, legally married same-sex spouses and their children are entitled to these benefits. Another implication of Obergefell involves loss of consortium claims in third-party auto negligence cases. A loss of consortium claim compensates the spouse of an injured person for the loss of emotional support and at times a physical relationship. Prior to Obergefell, this type of claim was not compensable for a same-sex couple, even if that couple was married in another state. Obergefell opens up these consortium claims to all legally married couples regardless of sexual orientation. The legal status of marriage between same-sex couples is also important in wrongful death cases. In the absence of the appointment of a personal representative, only a legally married spouse can bring a wrongful death action on behalf of a decedent for medical expenses, funeral and burial costs, and non-economic pain and suffering. The decedent's spouse is also entitled to survivor benefits in a wrongful death claim, including loss of financial support. Prior to Obergefell, gay and lesbian survivors could not make a wrongful death claim on behalf of their deceased spouse or partner. Michigan auto insurers should be cognizant of this ruling and its implication in handling claims filed by claimants who are married to a person of the same sex. As insurers and insureds in Michigan begin to navigate the legal landscape as shaped by the Obergefell decision, it's helpful to apply the view that same-sex marriage is simply marriage in the eyes of the law. Any and all rights traditionally afforded to legally married couples are now equally afforded to legally married couples who are of the same sex. So you simply take out the idea of the same-sex portion of a marriage. It's just a marriage. You treat it the same way in handling claims and defending cases. And finally, just for fun and to round out the presentation, because I'll use really any excuse to share photos from my wedding, here's a picture from my own wedding, which took place on September 2nd, 2013. At that time, gay marriage was not legal in Michigan, and we went to New York State to get married where it was legal. When we returned to Michigan, we dealt with certain uncertainties with regard to our legal status. For instance, when we filed our taxes, we had to file separately. We filed as single for our Michigan state taxes and as married for our federal taxes. When we had our baby, when we had our daughter, we had certain considerations for that whole process. And similarly, when we bought our house, we had concerns about our legal rights and protections at that time. On June 24th, 2015, Obergefell v. Hodges made my marriage legal in my home state of Michigan, and all of those uncertainties and questions were resolved and answered. Thank you for taking the time to attend the presentation. That's the end of the presentation. All of my contact information is now on the screen. If you have any questions about this topic or any other auto-related topic, please give me a call or email me at any time. I'd be happy to help you in any way. Have a good afternoon.